this legislation are works which, at the time they were created, were not protected in about 50 countries abroad. They are now protected in those countries because of our application of Article 18, and that's the tat for the tit of our recognizing copyrights of the countries that were already in Berne when we joined Berne.
That's just not true. There's no connection between the two, because by definition, this statute doesn't affect any works that were created after 1988. All the additional protection in all the additional countries you're talking about, we got because we were a member of Berne, and we were a member of Berne as of 1988. And that's not going to change whether we enacted Section 514 or not.
You seem to be assuming that we actually didn't have to comply with all the provisions of Berne in order to get the benefits of Berne.
Well,
no, I think we did.
We could litigate this Article 18 point over and over, but I don't know that it's actually going to be, the justices didn't want to spend a lot of time on that question. So you can have your say, but I just want to say my read of the justices was that's not particularly relevant to the Progress Clause argument, and it could be relevant to the First Amendment argument, and we're not there yet.
Well, here's why it's relevant to the Progress Clause, though, because when you look at to the extent that the Progress preamble to the Copyright Clause is anything that's enforceable, is anything that tells us what Congress can or can't do, then you have to ask yourself, when Congress legislates with respect to copyright, why is it doing what it's doing? Now, if it's doing it in order to enter into an international system which provides for protection of U.S. works abroad, and as a part of that requires us to protect foreign works here, that is something that I think is within the power of Congress under the Copyright Clause to do. It's not that the treaty itself is imposing that, and therefore it's a treaty clause argument. It's that in order to carry out copyright policy, and in recognition of the fact that we're living in a world that's getting smaller all the time, we have to engage with the rest of the world, and we have to make concessions in order to get protection abroad. So I think it's well within Congress's Copyright Clause power to do that.
If progress is even a constraint.
If it's a constraint.
Right, okay.
Well, and the other thing is that...
I need you to speak into the mic because we're being...
And the other thing is, I mean, on the one side you saw some questions. On the other side, you saw the same Justice Scalia, who's been known to, I guess the legal term of art is jerk chains of people who are up on the podium. But he also said, look, what about a billionaire who gives millions of dollars to a person that has already created works? He just says this was a great book. Is there any doubt that he's a patron of the arts or promoting its progress? And it seemed to me, based on that at least with respect to one person, that might be the way he views it, and that's certainly a reasonable way to view the Progress Clause.
So let me ask then a little bit about the limited times, and I frankly